Good morning. My name is Marty Mallon. I'm a professor here at Chicago-Kent and the director of our Institute for Law and the Workplace. It's my pleasure to welcome you to this program commemorating the 50th anniversary of the Civil Rights Act of 1964. We at Chicago-Kent have been privileged to work in partnership with the EEOC and the American Bar Association section on labor and employment law literally for decades on programs like this and a number of other matters. I invite you, there's a brochure out on the table in the front lobby describing our institute. I invite you to take one with you to familiarize yourself with us if you're not already familiar with us. And there are also brochures announcing some other upcoming programs. Our schedule today, we're going to have some opening remarks. That will be followed by a short video clip, and then that will be followed by the panel moderated by Commissioner Lipnick. There will be an opportunity for questions and answers. We have two wonderful student volunteers who'll be roaming the aisles with handheld microphones, so if you have a question, you'll be able to be heard. And then we'll hear from the ABA, and finally, I will close. So today is about employment law, so I'm about to engage in an exercise in employment relations called Introducing My Boss. The average tenure of a law school dean in the United States runs about 4 years, and it's dropping as the environment for legal education gets more and more challenging. We've been very fortunate that our current dean has tripled that, and we're much better off because of that. So it's a real pleasure to introduce the Dean of Chicago-Kent College of Law, Hal Krent.
Thanks, Marty, and welcome to this great event. You know, institutions sometimes have to take a reflection and look inward. And some of you know that we, as a school, Chicago-Kent, turned 125 last year. And no one writes a script about what you do for your 125th birthday. But now here, the EEOC is celebrating its 50th birthday, and the question is, what should it do? So I am delighted that we, in a small way, can contribute to the legacy and the celebration of the Civil Rights Act and the EEOC at age 50 today. And what I would like to do is have the pleasure of introducing you to the chair and commissioner of the EEOC, Jenny Yang. Jenny went to Cornell, and then she followed to go to law school at NYU, where I was pleased to attend as well, but she went a generation after me. She also served on the law review, and unlike me, she received the prestigious Ruth Tilden Public Interest Scholarship. Upon graduation, she clerked, worked for the National Employment Law Project, working with garment workers, and then went to DOJ, where she worked in the Civil Rights Division, working on discrimination acts in government employees. After that, she went to the firm Cohn, Milstein & Sellers, which is known as as my daughter says, a private public interest, which is a wonderful combination, and she was a partner there in engaging in very complex civil litigation matters of employment and civil rights, including years and years and years on the Walmart litigation. And she was appointed a commissioner, and was confirmed in 2013, and President Obama chose to appoint her as chair in 2014. So with that, delighted to welcome Commissioner Jenny Yang.
Good morning. Thank you, Dean Kent, for that very generous introduction. We learned that we have many connections, and it was great to hear about that. I really want to thank you all for joining us today. I could feel the energy in the room and the excitement that everyone has for being here as soon as I walked in the door. And I know it is because we have an extraordinary panel of people to hear from today, people whose stories have inspired me. And I am so looking forward to hearing about what motivated you and what you think now about the accomplishments that you've made. I really want to thank our co-hosts and co-sponsor, Chicago-Kent College of Law and the Institute for Law and Workplace, led by our Master of Ceremonies, Professor Marty Mallon, as well as my colleagues, Commissioner Vicki Lipnick, for being the visionary force behind this event. Her special assistants, Jim Peretti and Donald McIntosh, and my special assistant, Joy Cheney. And I also want to thank Chicago District Office Deputy Director, Julie Bowman, for making this all happen. I also want to thank our co-sponsors, the EEO Committee of the ABA's Labor and Employment Section, and in particular, Chris Meacham and Paul Malika. who are representing the section today. And I also want to thank all of you who worked behind the scenes at the law school and the EOC to make this event possible. Your contributions are truly appreciated. It really is an honor to be here with you all to celebrate our year-long commemoration of the 50th anniversary of Title VII. The Civil Rights Act of 1964, and particularly Title VII, have been so meaningful to us as a nation. And we couldn't have come anywhere near where we are today without the courageous acts of women like we will hear from today. We know that we stand on their shoulders in all that the work that we continue to do at the agency, and we continue to learn from their inspiration. I also want to acknowledge all the students in the audience. You all are the future of our legal practice, and I hope the stories that you will hear today show you the tremendous power of the law when courageous individuals are willing to step forward and demand its enforcement. I also bring you greetings on behalf of my fellow commissioners, Connie Barker and Hy Feldblum, who could not be with us here today but are here in spirit. And I also want to acknowledge the leadership of our General Counsel, David Lopez, who is here today. Can you please stand? One of the things I've most enjoyed since joining the Commission nearly a year and a half ago is the opportunity to visit our district offices around the country. I want to thank everyone in our Chicago office for hosting me yesterday. I really had a terrific time. And I want to recognize our district director, Jack Rowe, who you will hear from shortly, our regional attorney, John Hendrickson, and our deputy director, Julie Bowman. Can you all please stand too so everyone knows who you are, if they don't already? Thank you. The work of our Chicago office has been groundbreaking in so many ways, and we know that both the EOC and our country has benefited from much of their visionary work. So I thank you all and the entire Chicago team. It is truly an honor to serve as chair of the EEOC. In this job, I get the chance to work with nearly 2,300 individuals who are dedicated to our singular mission of stopping and remedying discrimination in the workplace. This historic anniversary gives us a chance to look backwards on all that we have accomplished and all those we have to thank for those accomplishments. It also gives us a chance to think about the challenges we have ahead to truly realize the promise of the Civil Rights Act of 1964. 50 years ago, the Civil Rights Act created the EEOC to enforce its new prohibitions against employment discrimination on the basis of race, color, national origin, religion, and sex. Commissioner Lipwick will tell you more today about how that important provision on sex made it into the statute. When we opened our doors on July 2nd, 1965, it was a year after the day that the Civil Rights Act had been signed. And so this year, we are celebrating our golden anniversary. Well, the Civil Rights Act in July will be celebrating ours. And today, we know we have made much progress for women in the workplace. Nearly half of our workforce is now female, and we have an increasing percentage of working women with young children in the workforce. And thanks to the groundbreaking work of our flight attendants, we no longer have policies barring married women from serving in certain jobs. In fact, it sounds somewhat preposterous now to think that that could have been the law not so long ago. And we know that it is not the law alone that made this progress possible. It was the work of the women who we will hear from today, and so many others who supported their efforts to build a case to demand fair treatment in the workplace. Our panelists today will talk about how they spoke out against policies, unequal pay, bans on married women, weight restrictions, and other barriers that created widespread inequality for women across large segments of our workforce. Their work extended beyond Title VII, as they also prevailed in striking down arbitrary age restrictions for women as flight attendants. And the impact of these women extended far beyond just the flight attendant industry. It began to change deeply entrenched views about women's roles at home in our society. They showed us that if people are willing to come forward, change will happen. The work at the EEOC depends on people like these women willing to come forward into our offices around the country to learn about the laws that protect their rights at work and to file charges so that we can pursue solutions to discrimination in the workplace. While we thank all of those for their important contributions, we must also all recommit to making continued progress because we know the work is not done and we must finish the job that we started 50 years ago. Today, we continue to see some of these very same stereotypes about women's roles that are slow to change. In cases I have litigated in my career and seen since joining the agency, we continue to see stories where men are paid more because they have a family to support, but yet women are viewed as not committed to their work because they have a family. We have seen widespread sexual harassment still today in all kinds of workplaces, particularly restaurant industries, retail, and especially for some of the most vulnerable women, including immigrant farm workers. In the last decade, the number of pregnancy discrimination charges have increased by 35%. And women continue to face harassment, demotion, decreased hours, forced leave, and even job loss when they become pregnant. In fact, 70% of our charges today alleging pregnancy discrimination allege that people were terminated because they are pregnant. So that is why the EEOC issued pregnancy guidance this summer. So we think that's an important way to encourage businesses to prevent discrimination from happening in the first place. We also continue to see widespread occupational segregation, particularly for women in traditionally male occupations. David Lopez has really led the way in many of our cases that have challenged barriers to women trying to enter jobs that provide higher pay. We've seen it in trucking, mining, construction, and public safety, as well as many other occupations. And we've seen that even when women can make it in the door, often they are then subjected to harassment or denied training opportunities that they need to succeed in the job. So we see that although we have these persistent stereotypes, and they affect women at all levels, including women who are seeking leadership positions in the very top of their organizations. Many women face this dilemma where on the one hand, people may think that they don't have the leadership skills because they are not acting in an authoritative and directive way, when in fact a more collaborative style may serve them equally effectively. On the other hand, some women who do exhibit that behavior face a backlash because they're viewed as overly aggressive and confrontational. So there are challenges for women today at all levels in our workforce. But we know that we're changing that. Sometimes progress is slow, like the 14-year case that we will hear about today. But it makes a difference. Where people are committed, often at great sacrifice to themselves, they know they are changing practices in the long term for the generations that follow. And those principles in the cases established by the flight attendants continue to guide us today. The idea that you can discriminate against people because of a custom or preference is one we continue to face. The idea that it's okay to discriminate because someone might think that's better for business is an issue we continue to see in our cases today, where employers may be trying to promote a particular image, cool, hip, all-American. What we've seen is that they're excluding from opportunity people who might not fit that image, people who may be people of color or older workers, and denying opportunities to qualified people who want to do this work. We use these precedents that have been established to continue to open opportunities for so many people in the workplace today. And so we all start today very inspired by these courageous women who have been a catalyst for us all to fulfill the commitment of the Civil Rights Act. We all want to work in a workplace free from discrimination, where we can do the work that we want to do. And we look forward to working with you all today because we will need all of you on the roads ahead. Thank you so much for having us here today. Very important responsibility that I was neglecting is to introduce to you our District Director, Jack Rowe. Now, it is really my pleasure because I have learned so much from Jack since joining this agency just over a year ago. He joined the EOC in 1973, and he has such an institutional knowledge of the agency and the law. He became our regional attorney in 1977, and he served in that position for 13 years until he became our district director in 1990. He has been an inspiration and a visionary to many and to us throughout the agency. So I am so happy to be able to introduce him today. Thank you.
I'm not sure who wrote that, but it's all right. No corrections need not be made, I don't think, as long as my boss has said them, they are law as far as I am concerned. Marty was talking about the problem of introducing his boss. I'm feeling a little squeezed here with my boss on the one hand and another member of the commission on the other hand, and it's a good thing they don't really have any person to report to on my conduct or performance, because that's the top of our shop, and we've had awfully good relations with all of the current serving commissioners, but we're, I must say, thrilled with the current appointment of Jenny Yang as chair. We hope she's going to be around with us for a very long time. I want to thank both of our institutional co-sponsors, both the Institute and the ABA folks. Without assistance from co-sponsors, we have a very difficult time finding the resources and the staff time to provide these stories. And I want to dwell just a second on the term. A lot of what we have in us that do employment discrimination work is we wind up with stories. I'm inclined to say that those of us who work on behalf of employees have better stories, but that's for someone else to judge. That's, at any rate, that's the part of the job that we like a lot. Having said that, I want to introduce to you one of the commissioners who has had a great deal to do with the fact that we do operate on a bipartisan basis, and we have been able to locate common ground in making policy and in making judgments as to litigation decisions as well. So it's just good to not be internally at war, even though if you look at the statute, it makes it look a lot like Congress thought war would be entertaining, or at least it wouldn't do no harm. But believe me, having been 40 years here, it's a lot better to have a group that can set policy for those of us who are out in the field to follow. And I want to talk about Vicki a little bit, but the first thing you need to know is that not only do we have institutional co-sponsors, but our own headquarters has been richly involved in putting together this program, and that certainly includes Commissioner Lipnick and her office staff. Great deal of help from those folks. Commissioner Lipnick has been heavily involved in the issues revolving around sex discrimination, and that is certainly a matter of, let me sort of cast that in an example. I think it was 2011, 2012, when, we were all a little newer at this, but there was in force the amendments to the ADA. Commissioner Lipnick and one of her fellows on the commission undertook to give the information to as many people as possible, and they did it in the most complete way you can. They went to the Pacific Ocean beaches. They made a trip across the entire country and generated a great deal of excitement and interest in the new definitions that are contained in the ADA amendments. It's made it from a statute that was very difficult to enforce to one that, because people know the right things about it, we do a lot of work in this area now, and we do it successfully. In addition to talking about the information giving part of the commissioner's work, she's been a great partner with her fellow commissioners in the whole raft of sex discrimination issues, whether we're talking about sex harassment and why is it, because that's the real question, why is it? About pregnancy discrimination, because as the chair mentioned, we have a huge onslaught of new charges. Frankly, I don't know whether that's because people are becoming more and more aware of their rights. Unfortunately, if I had to guess, I would say it's because employers have in some instances found out what they can get away with. So there's going to be a lot of foment around the issues of sex discrimination, including harassment, including promotions, including all of the glass ceiling issues, so as to sort of make it worthwhile for all of us to think about these issues and talk about these issues and help each other through these issues. I am down here, I think, for a few minutes of introduction. I've already overstayed that by quite a bit, but I do want to introduce to you now Commissioner Vicki Lipnick.
Thank you very much, Jack, for that nice introduction. Good morning, everyone. I also want to thank, as our new chair, Jenny did, the Chicago office of the EEOC, not only for their help with this event, but for the really, as Jenny said, the incredible work that they have done over the past 50 years in advancing equal employment opportunity, not just for so many people in the Midwest, but I can tell you with great admiration that the work of the Chicago EEOC office has been groundbreaking and made an impact for so many people throughout the country for so many years. So thank you to all of you for all the work you've done. I also want to take a minute to thank our hosts and sponsors, the Chicago-Kent College of Law and the American Bar Association section of Labor and Employment Law, for joining with us in putting this event together today. We quite literally, you can ask our ethics lawyers, would not have been able to do this event without you. So, and for the record, we did clear it all with our ethics lawyers. So, about a year ago, I sat down with our then chair, Jackie Berrien, to talk about what sort of things we could do as a commission to celebrate and commemorate the 50th anniversary of the Civil Rights Act, a monumental legislative achievement, the likes of which we have not often seen in the years since, the kind of law that brings about transformative societal change. As we discussed planning for events around the country, I said that I would like to put together an event that would recognize the significance of the provision added into Title VII, the employment provisions in the Civil Rights Act, which I have to say, those of us at the EEOC think are the premier provisions in the Civil Rights Act, to protect against discrimination based on sex. My research into that provision, of course, led me to the early cases which helped bring it to life and led to the women who are here with us today. Now, I have to say, I know many people, including my staff and the chair's staff, kept asking, why are we doing this event in Chicago? And, wouldn't this be easier if we were doing this in Washington, which, of course, it would have been. But honestly, I think that I really just had in my mind Chicago, O'Hare Airport, United Airlines. I fly in and out of there all the time. Why not do it in Chicago? Anyway, before I introduce our panel, I first want, and I should also say that, my staff who've just done an amazing job, and I do want to, in particular, as Jenny did, recognize Jim Peretti and Donald McIntosh on my staff, and Joy Cheney and the chair staff for all the great work that they did in putting this together. So, and I have to say that Jim, who was so stressed out about all of this, in particular about making sure that all of our attendees got here today, and was so worried about their flight arrangements and everything, and I said, Jim, they're flight attendants. These are sophisticated travelers. I think they know what to do when they get to an airport. So, anyway, before I introduce our panel, I do want to set the stage a bit for our discussion today by recalling to you a bit about the forgotten history of how the discrimination based on sex was added into the law and how it almost did not come to pass. In 1963, when President Kennedy's Civil Rights Bill was introduced in Congress, there was no provision in the bill to protect against discrimination based on sex. At that time, the country was so rocked by the tremendous racial discrimination and segregation that most members of Congress believed the compelling need that needed to be addressed by federal legislation was solely to correct that racial injustice. When President Johnson took up the cause of passing the Civil Rights Bill in 1964, still no one was contemplating including a provision about discrimination based on sex. The year before, the commission that had been established by President Kennedy, the Commission on the Status of Women, which had been chaired by Eleanor Roosevelt and issued its report in 1963, and in 1963, Congress passed the Equal Pay Act, which required equal pay for equal work. So most members of Congress thought, didn't we deal with this a year ago? But in February 1964, in the 11th hour of the debate on the floor of the House of Representatives, Congressman Howard Smith, a Democrat from Virginia, offered the amendment to prevent against discrimination based on sex in employment. There was no legislative history. There had been no committee hearings, nothing. No one knows Congressman Smith's true motivation. For many years, the history as told of the bill was that Congressman Smith, who was an avowed segregationist, had offered the amendment as a poison pill to bring down the entire Civil Rights Bill. Because Congressman Smith, and of course many members of Congress, many men at that time, ultimately voted against the Civil Rights Bill. Now, further history is a bit more complicated as to Congressman Smith's motivations. He had, in fact, been a longtime supporter of the Equal Rights Amendment, and according to the League of Women Voters in Virginia, many of whom I know and who knew him at the time, he, in fact, had been a friend of Alice Paul, who was one of the most famous suffragists. At that time, in 1964, there were only 12 women serving in the United States House of Representatives. Many of those women who served in the House at that time were the first women ever to be elected from their states to serve in the House. Most of them were not college graduates. When Howard Smith offered that amendment to the bill, the 12 women in the House, save for one, that sisterhood, as I like to refer to them, rose up to support it. Two women in the House in particular, Margaret Wright Griffiths, a Democrat from Michigan, and Catherine St. George, a Republican from New York, carried the debate. And in fact, there is history to suggest that Congresswoman Griffiths was going to offer a similar amendment if, in fact, Congressman Smith had not offered it. The amendment passed by a vote of 168 to 133. The action then moved to the Senate with that protection for women in it. And by the way, for those of you who are or were ever collegiate athletes, many of these women who served in the House at that time are also the same women who a decade later were responsible for passage of Title IX. There were only two women serving in the Senate at that time: Maureen Brown Neuberger, a Democrat from Oregon, and Margaret Chase Smith, a Republican from Maine. Margaret Chase Smith was a remarkable stateswoman. She was the first woman to serve in both the House of Representatives and in the Senate. And some of you may recall that she was responsible for a very famous speech on the floor of the Senate, a call to conscience, which helped bring down the end of McCarthyism. When the Civil Rights Bill went to the Senate, the men were going to offer an amendment to strike the sex discrimination provision, including, I hate to tell all of you here in Illinois, the great Senator Everett Dirksen from the state of Illinois, who was the leader of the Republican caucus. He was going to offer the amendment to strike it. The call went out to the group of women activists who had been working on the Equal Rights Amendment for many years to provide background and supporting material to the senators. Now, and of course, this is when people used telephones and the mail and did not have, the internet or every other, thousand means of communicating with each other. Senator Margaret Chase Smith was given a legal memo written by a woman by the name of Polly Murray. Polly Murray is one of the great unsung heroes of the Civil Rights Act. African-American woman, lawyer, activist. She had served on the President's Commission on the Status of Women just the year before, and she had done a lot of the legal work that was underpinning that report. At this time, she was a legal scholar studying at Yale. In the memo that she presented to Senator Smith, she explained not only the legal rationale for why the law needed to include this provision based on sex discrimination, but she also explained, in her words, the historical interrelatedness of the movements for civil rights and women's rights, and the tragic consequences in United States history of ignoring the interrelatedness of all human rights. She made the legal case and the moral case for why half the population, the women, could not be left out of the civil rights law. And of course, the consequences for African American women would be especially dire if women were left out of the bill. Margaret Chase Smith immediately got it. She quite literally got the memo. She went to the meeting of the Republican conference. And keep in mind, at that time, for the Civil Rights Bill to pass, they had to have a vote of the majority of the Republican members because the Southern Democrats were all opposed to the bill. They were filibustering the bill. This, again, is in the 11th hour of the debate on the Civil Rights Bill. She goes to this meeting. She is the only woman there among 34 senators. And in her words, I stood up and opposed and argued against the amendment to strike the sex discrimination provision. In doing so, I marshaled so much Republican opposition to it that Senator Dirksen decided not to introduce his amendment to strike it. When that provision was added into the law, it transformed the Civil Rights Act to include everyone as citizens, and it revolutionized the workplace. 1 year later, in 1965, the EEOC opened its doors. When charges first started to be filed with the EEOC, the Commission later admitted in a report to Congress that it was stunned when more than 1/3 of the charges of discrimination filed in that first year were based not on race, but on sex. Little did the newly formed EEOC, the Congress, or the country at large know that there was a group of women who had been preparing themselves for years to take up the cause of giving real meaning to those words "because of sex" in the statute and vindicating their rights and the rights of so many women under the new law. Those women who were waiting in the wings, or perhaps I should say waiting with their wings, join us today. And so, before I introduce our panel, now that you have some of the history of the law, we are going to show you a short presentation of a larger documentary put together by the Flight Attendants Union that will give you a little flavor of some of the history at that time.
By 1952, the government required airlines to have flight attendants because of safety. But the real change in the profession came with the onset of jet air travel.
Screeching in of the jet age had to be one of the biggest changes that flight attendants faced. Our numbers doubled. So we could go from coast to coast in half the time with twice the passengers.
Georgia Nielsen became a stewardess in 1960.
When I started flying, we were expected by my company, by United, to be rather the girl next door, the type of woman that, or girls as they called us then, that our passengers might like to take home to meet their mother and to marry them.
Susan, would you like a junior stewardess pin?
Oh, yes, thank you.
And how would you like to be a junior pilot?
Oh, I'd love to.
The expectations were quite conservative, too. Our behavior was rather monitored, and nice women did certain things. We wore white gloves, for example.
One 1960s air passenger commented, "Stewardesses are America's Vestal Virgins." The Vestal Virgins of the air were not expected to stay beyond the usual tenure of 18 months before they found suitable husbands.
You sit down in this seat right here and I'll demonstrate some of our features.
Would you do that for me?
Push this little button here. Lean back.
Taking a lover often meant termination. A pregnant stewardess had two options: give up the baby for adoption or obtain an illegal abortion.
Take me along if you love me. Take me along if you love me. Take me along with
I love you, little cutie, but the office is my duty.
my heart will rise. Sweet glorious.
Air travel was changing dramatically, and so were the country's mores. Stewardesses became a symbol for some of those changes.
As time went on, exploitation surfaced in the 60s after I started flying, and I looked around and our skirts were getting shorter, mine too, and at the same time I was getting older and something was happening.
I'm strong if you will take me along with you.
In the 1960s, National Airlines came forth with one of the worst ads. It said things like, "I'm Cheryl, fly me," or "I'm Georgia, fly me," or whatever the person's name. These were real people that they used. That was a very painful time for many of us, because at about the same time we were suddenly becoming a little more aware of where we were in American society and where we felt we needed to be.
Graduation day at United Stewardess College.
I hate to wake you up to say goodbye, but the dawn is breaking, it's early morning.
It's a happy day for the girls and their parents.
I'm so excited.
The 1965 Civil Rights Act would have a tremendous impact on the lives of flight attendants. Although most carriers relaxed the no marriage rule in the late 60s, it was not until the 1970s, through litigation based on the Civil Rights Act, that women flight attendants firmly won the right to be married and keep their jobs. The stewardess union.
Okay, well, that was a different time, wasn't it? So if I could now ask all of our panelists to come up on stage, and then we can have our discussion with them. And I'll introduce everyone from here and then join you here on the panel. First we have Kathleen Berry, who is an historian, and she is the author of Femininity in Flight, a history of the flight attendants, which I have to tell you is a fascinating book and incredibly, not incredibly well researched, but just a wonderful read. So I recommend it to all of you. And I have to tell you, Professor Berry, I have been on so many flights in the last couple of months, and I've had this book, and every flight attendant has said to me, "What is that?" So, our next panelist, Sonia Fuentes. Sonia Fuentes was the first woman hired in the General Counsel's office when the EEOC opened its doors in 1965. She was the first female attorney hired by the EEOC. Next, we have Mary Celeste Lansdale Brodigan. Mary Celeste was the leading plaintiff in Lansdale versus United Airlines, challenging the airline's policy of discharging female employees from marrying. Next, we have Mary Pat Leafy Inman. Mary Pat was the leading plaintiff in Leafy versus Northwest Airlines, challenging the differential treatment of male and female flight attendants in hiring, pay, promotions, and benefits. Next, we have Patricia Friend, who is the former international president of the Association of Flight Attendants. And distinguished member of the faculty here at the law school, Mary Rose Struby, who is professor of law and the assistant director for the Institute for Law and the Workplace. And I don't know, for those of you who are students, I don't know if you know, but she began her legal career working on the hearings after the challenge to the marriage rule in the United Airlines case. She worked on the hearings that litigated the women who were able to go back to work for United Airlines. That's how she began her career. And of course, our distinguished chair, Jenny Yang. So with that, we're going to have I've asked each panelist if they could provide us some background and make an opening statement, and then we'll get into our discussion. And in particular, I first wanted to ask Professor Berry, since she is steeped in the history of women in aviation, if she could lay the stage for us for some of the history of the flight attendants themselves.
Thank you very much. First, I'd like to say what an honor it is to be here to be part of this event and part of a panel with such an impressive group. Hopefully, I'll be able to offer a bit of historical perspective today because I can't offer anything in the way of firsthand experience the way my fellow panelists can. So what I'd like to do is talk a bit about the decades before Title VII, trying to sketch the backstory leading up to flight attendants' use of Title VII, and also suggest what I think is so historically remarkable about flight attendant struggles for a fairer workplace. Now, on the one hand, we have female flight attendants' role as cultural icons, something I think the video did a very nice job of giving you a good sense of. Journalists, filmmakers, novelists, and of course airline marketers began glamorizing female flight attendants, or stewardesses as they were long known, the very first moment they were hired in 1930, and the glamorizing never stopped. Indeed, as we heard in the video, stewardesses were, quote-unquote, America's Vestal Virgins, a wonderful quote that really captures, I think, just how celebrated female flight attendants were in the mid-20th century. And in the earliest years, in the 1930s, a nursing degree was required, and commercial aviation at that point was still a bit rough and ready, you might say. The earliest stewardesses were held up as marvels of feminine bravery as well as nurturing. By the post-war years, the nursing requirement disappeared, and commercial aviation had become a more regular, if still elite, part of American life. Stewardesses, by this era, had become ideal brides-to-be in the popular imagination, a more cosmopolitan version of the girl next door. And then, beginning in the mid-1960s, as the video nicely showed, came the Fly Me era, we might say, when female flight attendants found themselves wearing miniskirts and other provocative items, and featuring in all sorts of more provocative airline marketing, along with novels and films with titles like Coffee Tear Me and The Fly Girls. And by the Fly Me era, as Georgia Nielsen explained in the video, many flight attendants were really becoming disenchanted with their glamour girl image. But I do think it's fair to say that in earlier years, many female flight attendants found their celebrated status at least somewhat flattering, if not also something kind of special about this job, something that made it unique. But on the other hand, we also have decades worth of organizing and activism going on behind the scenes while stewardesses were being celebrated as America's Vestal Virgins. Flight attendants began a successful movement to unionize at United Airlines in 1945, and by the 1950s, most of the flight attendant workforce had joined the union, at that time the Airline Stewards and Stewardesses Association. As a result, most flight attendants had won better wages and better working conditions. The union, however, at the very outset, had entered into an unequal affiliation, or what we might call a marriage of convenience, with the much wealthier and more powerful pilots' union. They did this because flight attendants were a relatively small group before the jet age, and they felt that they needed the affiliation with the pilots to get the union well established. But from the start, at least some flight attendant leaders were uncomfortable with the pilot union's oversight and hoped that eventually flight attendants could have their own independent union within the AFL-CIO, rather than continue on as a subordinate adjunct of the pilots' union. Flight attendant activists had other ambitions as well in the decades before Title VII. Keenly aware that at least some stewardesses would have liked the option, at least, to stay on the job after marrying, the union repeatedly protested to company officials about the virtually industry-wide no marriage rule. And as several airlines introduced age ceilings of 32 or 35 in the 1950s, the union also registered its unhappiness with these new discriminatory policies as well, policies like the marriage ban that were never applied to stewardesses' male coworkers. And finally, post-war flight attendant activists lobbied to secure federal safety licenses, just as pilots, mechanics, and all other workers connected to flight safety already had. Now, the results of all this activism were not what flight attendants hoped for. Union leaders tried to break away from the pilots' union in 1960 and get an independent AFL-CIO charter, but ended up instead really provoking a bitter struggle between the flight attendant and the pilots' union and among flight attendants themselves, and the outcome of this was two new unions, but ones that remained adjuncts of male-dominated parent unions. In one case, the Transport Workers Union, in the other case, the pilots' union. In 1962, flight attendants did manage to get a safety licensing bill into Congress, but it never made it out of committee. And finally, the union's efforts at the bargaining table and their occasional grievances against marriage and age restrictions really failed to make any changes in airline policies in the years before Title VII.
Professor Berry, can I ask you to be a little bit closer to the
Oh,
microphone.
I'm sorry. But even if activists' accomplishments fell short of their ambitions, I think it's the ambitions that are really important, especially when we consider them alongside stewardesses' glamour image. Now, to be sure, not every stewardess was a committed activist, far from it. But even so, to have at least some of this celebrated group acting occasionally as union and feminist activists from the 1940s on, late 1940s onward, that to me is remarkable in itself, especially considering that most left the job within a few years. So how do we make sense of all this activist energy coming from a group that hardly seemed like a likely source of militancy? Well, I think it makes perfect sense for two reasons. First, flight attendants' efforts, I think, were really a way of countering the airline-promoted idea that their work was not really a job at all, but an effortless expression of feminist charm and nurturing. And that was really what airlines had promoted for many decades, this idea. Now, flight attendants, in essence, I think we're saying, the flattery of glamour is fine to a point, but don't forget that the work we do in the cabin, the safety as well as the service aspects, all of that is worthy of respect as skilled work. And they wanted to acknowledge, too, that the glamour image itself required additional effort. All the impeccable grooming, flawless uniforms, unflagging charm, all of that airlines demanded, well, that was work in itself, too, but it was also work meant, ironically, to make all of what they did seem effortless. When flight attendant leaders testified before Congress or talked to reporters, they often made a very careful point of explaining all the behind-the-scenes work and duties involved in their hostessing role. And as activists shrewdly pointed out, mastering this work was something that they got better at the longer they stayed in the job. So why fire them just because they turned 32 or got married? Changes that passengers hardly or ever noticed. And secondly, I think there's a kind of irony in the demographic that the airlines sought. On the one hand, female flight attendants were well-educated, widely admired, and adventurous women, women who wanted to see the world, after all. That's why they took the job, or went after the job. There were also resourceful women who needed to work pretty independently in the cabin and handle a very wide range of mental and manual labor. But on the other hand, airlines subjected these same women to petty harassment over their appearance, cut their careers very short, and portrayed them as if all the hard work they did was somehow simply feminine magic. As I kept wondering while writing my book, why would the airlines ever have thought that these women would be so docile, so unfailingly accepting of patronizing treatment? Well, as it happened, they weren't such a docile bunch after all. When the EEOC opened its doors in July 1965, flight attendants had 2 decades of experience in organizing, protesting, and lobbying, so they were more than ready to act when this dramatic change in employment law came along. Now, since we have some of these remarkable women here today who are essential in the struggle from that point on, I'll leave it at that. Thank you.
I think I might stay here at the podium because it's easier for me to see all of you. So, Sonia, if you could tell us a little bit about your history. There you are, the first woman hired in the General Counsel's office, the first female attorney at the EEOC.
Good morning. I've been waiting for an event like this for 46 years. There's a Yiddish expression, as men lebt, der lebt man alles. If you live long enough, you'll experience everything. So I want to thank Commissioner Lipnick and Jim Peretti back there, with whom I've been working to make this event a reality. On May 1st, 1934, 1 month short of my 6th birthday, I arrived in the United States. I had escaped from Nazi Germany with my immediate family, and the previous year, after spending 9 months in Antwerp, Belgium, my family left there too. By that time, my life had been saved several times. First, by my family's leaving Germany. Second, by our not being granted visas to remain in Belgium. And third, by our avoiding 2 attempted deportations to Poland while we were in Belgium. This left me with the feeling that was with me from the age of 10, that my life had been saved because there was something I was meant to do. I found that purpose on October 4th, 1965, when I joined the EEOC as the first woman attorney in its Office of the General Counsel. At that time, the office consisted of 4 individuals: Charles T. Duncan, the General Counsel, a former lecturer at the Harvard University Law School in Washington, D.C., and a former principal assistant U.S. attorney for the District of Columbia. Dick Berg, the deputy general counsel, who believed a woman's place was in the home. John DeLessio, a junior attorney, and me. After graduation from the University of Miami School of Law, I had worked for 8 years for the federal government in Washington, D.C., first in the then Office of Alien Property, part of the Department of Justice, and then at the National Labor Relations Board, the NLRB. Title VII of the Civil Rights Act of 1964, which had created the EEOC to enforce the prohibitions against discrimination in employment based on race, color, religion, sex, and national origin by covered employers, employment agencies, and labor unions, was based on the National Labor Relations Act, which had created the NLRB. So I had a good background in labor law for my new job. I joined the EEOC 3 months after it had commenced operations. At that time, the EEOC consisted of about 100 permanent employees. Most had joined the EEOC to fight employment discrimination based on race or color, and they did not want the EEOC's resources diverted to issues of gender discrimination. And furthermore, they did not know how to interpret the sex discrimination prohibitions of Title VII, which raised more difficult questions of interpretation than the prohibitions of discrimination based on race or color. In short order, I became the EEOC staffer who spoke out about the need to enforce the sex discrimination prohibitions of the Act. And my boss, Charlie Duncan, for that reason, took to calling me a sex maniac. One of the early issues that came to the commission and my desk were charges of employment discrimination based on sex filed by women flight cabin attendants, then called stewardesses, who served on domestic flights. They filed complaints because, among other things, they were grounded or terminated when they reached the age of 32 or 35 or married, policies that were not applied to male flight attendants called pursers, who served on international runs. The EEOC gave much consideration to these cases and held 2 sets of hearings on the issues raised. When the commission decided that the airline's practices violated Title VII, the general counsel assigned me the task of writing the lead decision, which I did. And Commissioner Lipnick suggested you might like to hear some anecdotes, so I'll tell one now. After I was assigned to write the decision, the vice chairman of the EEOC, a former minister named Luther Holcomb, who also thought women's place was in the home, called my boss, Charlie Duncan, and said he heard that I had been assigned the task of writing the decision, and he was calling to ask Charlie to take that assignment away from me. And Charlie asked him why, and Luther Holcomb said, because I was prejudiced. And Charlie asked him what he meant by that, and he said I was in favor of women's rights. So Charlie Duncan, to his everlasting credit, turned that request down. Some of my co-panelists will now discuss these early stewardess cases from their various perspectives. Thank you.
So Celeste, you were the leading plaintiff in the Lansdale versus United Airlines case, challenging the no marriage rules. So if you could tell us your story.
Well, first of all, I'd like to give you a little card that Boeing put out years ago. It says, all the heroes of the past were not captains of the ship.
Ah.
I was born in 1939, and in 1940, I was kissed by Eleanor Roosevelt. probably had something to do with the spirit that I had as far as fighting discrimination. I'm not making this up. I really do have a flyer. It says, the New York Executive has a picture of an airplane, and underneath it, it says, for men only. I'm really not making it up. Only men could get on board the executive flights. Only men could be in the cockpit, and only females could be the cabin crew. This is another ad, and it's actually was published in many magazines, and underneath this picture of a lovely young lady, it says Old Maid. And this is what United Airlines was publicizing, that you could, the reason they called her an old maid was because she wasn't married yet and she had been flying for 3 years. Underneath, at the bottom, it says, everybody gets warmth, friendliness, and extra care, and someone may get a wife. So what they really were doing, they were peddling sex, as you already heard a couple of times today. Over a 35-year career, starting as a stewardess and retiring as a flight attendant, I became involved in many discriminatory practices. As a trainee, I learned about the first black flight attendant who was going to be hired, and she was released the night before graduation. Not a thing I could do about it, but I realized that going forward, maybe someday I might be able to. In 1964, I secretly married attorney Richard Bivens Lansdale. I flew secretly married for 4 years, and then I was fired, and I was fired for misconduct because I married the man that I was living with. It's hard to believe, but it really happened. I had worked for McGraw-Hill, and I read a lot of their articles, and I read about an Air France flight attendant who had been dismissed for being married, and the French court said this was against natural law. And I thought, gee, she got a lot of publicity out of that. I wonder if I could do the same if I ever needed to. Well, after I was fired for a year, I did everything legal, ethical, and moral to get my job back. And that I think I had covered maybe about 10 different areas. And then I finally said, oh, the hell with this. And I went to the newspapers and I said, would you like a really funny story? And they said yes. And this was the newspaper headline. Stewardess can live in sin, but not wed. The traveling public got in on it, and 7 days later, we had a marriage agreement. I was also disciplined for getting pregnant. Well, not for getting pregnant. I could get pregnant, but I had to tell them immediately. And I had already filed for divorce from my first husband. I used the proceeds from the settlement of the EEOC case to finance my divorce, which I thought was rather good way to spend my back pay. And then I married a pilot. Now, my first husband didn't believe that women should be in the cabin, or should be in the cabin. Didn't believe men should be in the cabin. My second husband did not believe that women should be in the cockpit, and made me very happy one day when I went to the cockpit and I saw the second officer reading Family Circle. So there were a lot of discrimination cases that were filed, and I think I was involved maybe in 13 of them. And it was a wonderful experience, and I was very happy to retire when it came about. Thank you.
Mary Pat.
Hello. The federal class action case, which I was named the named plaintiff, arose out of a personal claim to recognize
Wait,
my
Mary Pat, hang
senior...
on one second. Can everybody hear her?
Oh, okay.
Lean into the mic a little bit more.
All right.
There we go.
Start over. The federal class action case in which I was the named female plaintiff arose out of the personal claim to recognize my seniority and unfreeze my salary. While Northwest Airlines was an excellent airline, its management were also first-class chauvinists when it came to gender discrimination. The three most egregious policies were requiring female flight attendants to remain unmarried, retire at 32, and not allowing them to bid for purser positions. When the 1964 Act passed, it was clear these policies were illegal, and our Chicago-based union attorney, Gil Feldman, told us that in the 1966 new contract, we must remove all of these policies. The new contract in 1967 reinstated female flight attendants who had been charged for discriminatory reasons with their original seniority. That would be on July 6, de jure integration, 1965. The new contract allowed females to bid as pursers. Pursers were the only male attendants used on flights overseas and constituted less than 5% of all attendants. Nevertheless, they were put in charge of the cabin crew without regard to seniority and at a higher rate of pay. They also pretty much ran the union, but none wanted to be chairman, which required a lot more extra work without extra remuneration. And so in 1966, I became the chairman by default. Northwest, after the new contract was signed, immediately tried to thwart having females in the purser position by not putting up the bids for the females to bid. Afraid of the reaction of the pursers, no female would bid the position. We finally forced them to post the bids. Northwest took 8 months to come up with a new test for me, which all pursers had to take. I scored higher than all the rest of the males, and so became the first female purser. NWA still refused to honor my 10 years of seniority ahead of the 5 recently hired men. So I went to the bottom of the purser seniority list. They froze my salary until the bottom purser pay came up to the top stewardess pay. Because of my lack of seniority, I was forced to fly into Vietnam during the Tet Offensive, often witnessing shelling. For 2 years, I remained the only female purser. Then I sought legal counsel about my personal claims from Michael Gottesman, who is now a labor law professor at Georgetown University. He quickly perceived that there was a potential class action, and because females received a lower rate of pay than the pursers, we filed suit. We had an equal pay case. We filed suit in 1969 alleging the violation of both Civil Rights Title VII and the equal pay for women, and went to trial in December of 1971, with the EEOC filing an amicus brief on our behalf. The first DC court decision on appeal was in 1976. It denied all defendants grounds for appeal and granted all plaintiffs cross appeals, which required its return to the district court to take more evidence. The Supreme Court denied cert, and then Northwest managed to delay the appeal from the subsequent evidentiary proceedings for more than 6 more years. The second DC opinion, Laffey 2, was finally written in 1984 by Ruthie Bader Ginsburg And the older lawyers here present will be surprised at the names of the two judges who concurred in the opinion was Robert Bork and Ken Starr. Certiorari was again denied. The sheer size of the verdict in the Northwest case, $63 million in 1985 dollars, in what was perceived to be a 1964 Civil Rights Act case, only made a very large impression, not only made a very large impression on airline employers, but employers throughout the United States. It was more than 20 years after its passage. What is ironic is the size that caused two factors, nothing having to do with the Civil Rights Act. Damages were awarded for a 3-year period between 67 and 70, but were paid to individual plaintiffs in 1985, which meant that damages were doubled and possibly trebled by post-judgment interest at between 6 to 8% compounded over 15 years. Also in the award were attorney's fees and costs over the same period, which had to be paid by the defendant. The other factor was that wage and benefit damages were initially doubled under the 1963 Equal Pay Act for Women, signed by JFK, when it was proven that the pay disparities were intentional. That was called willful intent. It is possible that less than $10 million in actual damages were proved and by less than 2,000 stewardesses. There were about 2,000 stewardesses who were on the payroll with Northwest at that time. The principal impact of the 1964 Act on Northwest Airlines' verdict was the ending of objectionable practices. Females, unlike attendants, were to remain unmarried, retire at 32, become subject to wage checks, forbidden to wear eyeglasses, wear hats, and share overnight accommodations, and become pursers. It is often forgotten that the 1964 Act, as originally filed, had no provision in it for gender discrimination. A group of legislators, led by the Virginia Congressman Smith, attempted to defeat the racial provisions by amending the bill to include gender discrimination. That the strategy failed may well have been caused by female relatives or other congressmen or women. American females owe a great deal of gratitude to Martin Luther King and Lyndon Johnson for having the bill filed and under debate, which could not be amended. Otherwise, who knows when, if ever, gender discrimination would have been addressed.
Pat?
Thank you, Commissioner Lipnick and your staff for organizing this event to highlight the effects of Title VII on my career. I started with United Airlines in the fall of 1966, 2 years after the enactment of the law. There were, in my class, 39 young Caucasian women and 1 young African-American woman. After we completed training, but before we would be allowed to graduate, we all had to sign a document acknowledging that when we reached the age of 32, if we were still there, we would voluntarily leave our position. So 2 years later, nothing had changed. We were faced with all the same discrimination that my two friends here have talked about. Couldn't be married. The weight restrictions were based on United's weight restrictions were based on weight charts from an insurance company for men, and United did have a group of male stewards based in the Hawaiian Islands for their very special Hawaii trips. The men's weight standards were based on an insurance chart for large frame. The women's weight standards were based on an insurance chart for small frame.
And what was the average weight for women that they had?
I would guess the average weight was about 124. Yeah. So there were any number of ways that they could keep the workforce young and junior, either by getting them married off or forcing them out because they couldn't meet these completely unreasonable weight standards. Or if you managed to avoid all of that and reach the ripe old age of 32, they would still be rid of you. There's a lot of talk, and some of it I suppose is true, that the airline's reason for these discriminatory practices were, as they said, because that's what their customers preferred, and it was all part of the marketing image. But I think we can't ignore the fact that there was a very deep economic reason for this as well, because as long as they could keep the workforce from averaging about 18 months to 3 years, they kept their costs down. They didn't accrue pension liabilities. They kept people in the lower levels of the wage scales. So as much as they might have tried to claim that all of these discriminatory practices were some kind of a bona fide occupational qualification, I think there was a very deep-seated economic reason as well. But over the years, and with the courage of flight attendants like Celeste and Mary Pat, those discriminatory practices were eliminated. I don't think it's an overstatement to say that Title VII became the foundation of a career because it allowed women, and then in the early 70s men, to actually look long-term and make a commitment to this career and commit to making the changes that really recognized it as a safety professional and not just a marketing tool. So I hope that this generation and the next generation of flight attendants will come to understand how much they owe to Title VII and how much they owe to the women who had the courage to take their claims to this newly formed commission based on a newly enacted law. So, thank you.
Professor Strube, you find yourself then a young lawyer, and here's this new law. And
well, my experience certainly is.
And can I ask you to get a little closer to the mic too?
My experience certainly is much more peripheral to the development of Title VII than the people from whom we've just heard. But I think Patricia is absolutely right when she talks about Title VII as the foundation of a career for many, many people, not just in the airline industry. It seems absurd now, but the airlines did argue that no marriage rules were bona fide occupational qualifications, and that in fact stewardesses not only needed to be women, but they needed to be unmarried women as an essential part of the job. Those and the other rules took a while to get rid of, and the after effects of those rules, as you've heard, took a lot longer. Two of the longest running suits, the Leahy suit against Northwest Airlines, and then here in Chicago, the Roma Santa / McDonald's suit against United Airlines, involved hundreds of employees and ran for many, many years. When I graduated from law school and went to work in 1981, I was lucky enough to go to work for a firm that had been representing the named plaintiff in a suit against United Airlines at that point for 10 years already. I worked on the Roma Santa versus United Airlines suit for my entire time with the firm, which was a little over 4 years. I then left the firm and that case continued until the late 1980s. I doubt that the flight attendants who stepped forward as named plaintiffs would have had the nerve to do so had anybody told them that they were going to be involved in this litigation for more than 15 years. Indeed, I doubt that my boss, Tom Midas, now retired, would have had the nerve to take on this case had anybody told him that it was going to last for more than 15 years. But in addition to the oddity of cases that last that long, I think the other thing we have to reflect on today is the range of legal issues that these cases brought by the flight attendants against the airlines helped us settle in regard to Title VII. Title VII was still a new statute in the late 1960s and the early 70s when these women were filing their EEOC charges and then later many of them filing their lawsuits. The EEOC really wasn't sure in the beginning whether gender was a bona fide occupational qualification for stewardess positions. Nobody had challenged, despite the existence of the Equal Pay Act, the idea that stewardess positions were comparable enough to purser positions that there should be some comparative equality of pay there. Nobody had had time to challenge the idea that you shouldn't be required to quit or be fired when you got married. Nobody had challenged the idea that you were somehow inherently unable to do your job as a stewardess the day you turned 33, despite the fact that the male pilots and co-pilots and pursers faced no such mandatory retirement. They apparently were still able to do their jobs when they turned 33. The number of issues that these cases resolved for Title VII going forward is really astounding if you go back and look at them. Issues about class actions, about the timeliness of charges. The Roma Santa case was assigned in the Northern District of Illinois, first to a district judge, Judge Perry, and then later to Judge Moran. Judge Moran, long about 1981 or 1982, described the case as gargantuan when it became apparent that there were probably going to be 1,800 class members who wanted to be reinstated to their positions as stewardesses at United Airlines and who alleged that sometime between July of 1965 and November of 1968 they had either been fired or forced to quit when they either married or when their marriages were discovered. And in fact, of course, that's part of the reason that the case took so long. The idea, courts grappling with questions such as, when is reinstatement in a situation like this appropriate, where even though the liability of the employer has been established, to reinstate all of the class members would harm the incumbents, the present people, the present flight attendants in the jobs who hadn't done anything wrong, who had been hired by United either after the no marriage rule ended or who had simply not married or not been discovered during the pendency of the rule. All of these questions, how you calculate back pay, what you do with a class award of damages. So many of these questions were first addressed in the big class actions against the airlines. It was a wonderful education for me to work on them, but I think what we sort of need to remember as we're kind of giggling at the idea of what you have to quit when you get married is that these cases and the charges brought by these women were the vehicles that the EEOC and then later the courts used to work out an awful lot of the issues of this brand new equality in the workplace statute, and that without their courage in bringing these charges and these lawsuits, I am not sure that Title VII would be anywhere near as robust as it now is.
I'd like to interject something,
Yes,
if I
please.
may. Everybody's been tossing around the letters BFOQ as if you all know what that means. And it's not a word that people ordinarily hear, or letters. It stands for bona fide occupational qualification. And Professor Stubbe is right that the airline cases went a long way in explaining what that meant, and let me tell you where it came from. Title VII said you have to hire men and women equally for a job unless sex is a bona fide occupational qualification for the job. In that case, you can refuse to hire men or women depending on what the case may be. So the airlines at that time were hiring only women for domestic flights. And they said, therefore, Title VII doesn't apply because Title VII only requires equality. And we don't need to talk about equality because sex is a BFOQ for the job of flight cabin attendants. We only hire women. And therefore, if Title VII doesn't apply, we can apply any conditions we want to these women because there's no law prohibiting it. And they made the argument that to determine whether sex is a BFOQ for a job, you don't just look at whether the candidates can perform that job. You have to look at other intangible qualities on what they look like or what the customers want or whatever. And in the decision that I wrote in 1968 for the commission, we said no. BFOQ only means if members of one sex cannot physically, mentally, or whatever do the job, then sex is a BFOQ for the job. But if men and women equally can do the job, then you've got to hire men and women equally. And of course, the airlines were hiring men to be pursers. They called them pursers, gave them the same work, and sent them overseas. So that's the importance of the BFOQ thing in this particular case.
And I think that underscores also not only did these cases advance opportunities for women, but they advanced opportunities for men within the airline industry. So thank you so much, Sonia, for that. So I want to ask just a basic question to Celeste and Mary Pat and Patricia. So, when we hear this today, gosh, you get fired if you get married, you get fired if you get pregnant, you're disciplined if you gain 2 pounds. Why in the world did you guys want to be flight attendants?
Well, at 20 or 21, you don't think any of those things are going to happen to you.
That's right. You're not even sure you're going to live to be 32. You know what I mean?
Well, that's true. Celeste?
I wanted to travel again.
And you had lived overseas, right?
I had for
gone
many
to high
years.
school in London, and then this relates to the video that we saw and Professor Berry's book. And tell us a little bit about the whole marketing campaigns of the airlines that so objectified women and made it was all about sex sells and the wages of glamour, as Professor Berry puts it in her book. So
I
how
wish I had
did you
been
react to all of that?
I wish I had been in charge of their advertising budget. We just kept on working. We didn't like it. Once we started filing cases, we realized things would be changed. And I'd just like to add one thing. When I was in negotiations as a chairperson, and after the Celio Diaz case was settled, sex discrimination case brought by Mr. Diaz, and he won it against Pan Am. He wanted to be a flight attendant, wanted to be hired. And the company came in and I said, you promised once the Diaz case was settled, we would get no discrimination because of sex into the contract. And the company said, we're going to appeal. And I said, the Supreme Court made a decision. And he said, to God.
Just.
I think it is impossible to overstate how demeaning it was to work in that environment. Every flight attendant base had a so-called appearance counselor, and they had rulers to make sure that the height of your heel was proper, was at least as high as they thought it should be, and you had to get on a scale and actually be weighed in once a month. And
As if you were a jockey.
As if you, well, and then I recall one time when I was, I can't remember which union position I held, but we had a call from our Miami base, and they said, our scale is broken, and the company is using the baggage scales to weigh in the flight attendants. I mean, that's how demeaning it was to work in that environment.
And Vicki, you have to remember, in every job, women were discriminated against in those days. So it wasn't unusual for the stewardesses to be treated the way they were treated, because whatever jobs women applied for, if they applied for legal jobs, they were sent in the back where they wouldn't have to deal with clients and to do research. I was once interviewed for a job in Chicago, as a matter of fact. The interview was in Washington, and a man had become the head of the trial section of a Chicago firm, and he interviewed me. This was shortly before the passage of Title VII. And then he wrote me a letter, black and white, and said that he wanted to hire me, but the two senior partners would never countenance the firm's hiring a woman. So there was nothing I could do about that letter. It wasn't against the law. So wherever you looked, women were demeaned.
The one, and just on the point, though, about sort of this marketing campaigns by the airlines, and Professor, you talk about this in your book, that, I mean, part of the interesting thing to me is you all became flight attendants in the early 1960s, but the real sexual revolution starts to take place in the early 70s, right, late 60s and early 70s. So as you are becoming more activist and aware of these discriminatory policies by your employers, at the same time, the marketing campaigns are becoming even more, objectifying women. And I wonder how you thought about, what did you think about that? Or were you conscious of that at the time? And
yes, but things were changing. I'd like to add that when the first male flight attendants were hired, they had to conform to the same standards that the females had. And so they were only hiring jockeys. And that really didn't make for good publicity, so things changed.
And actually, Celeste, you had mentioned me when we had spoken last week, since you brought the case challenging the no marriage rule, that you maintained 2 phone numbers while you were married. Is that right? And that a lot of women did?
You had to. And you just had to be careful who was picking up which phone.
So I also want to ask Patricia in particular, tell us a little bit about the union politics on this are so interesting. And for a long time, and as you all said, when you agreed to be a flight attendant, you signed this agreement that went along with these no marriage rules. And there were grievances filed for many years by your unions challenging this, but weren't getting anywhere with the arbitrators. So tell us a little bit about some of what was going on with the unions, and then the necessity then for what Title VII then did for that breakthrough.
Well, I mean, the problem is that we faced exactly what Sonia talked about, is there was no law that precluded what they were doing. So, protesting and arbitrating really was getting us nowhere because we had no foundation to fall back on. I could comment a little bit on what Professor Strube said about she referred to it as Roma Santa. I think we knew it more by the second, by McDonald. And the union found itself in a position of defending the position on the seniority list of the incumbent flight attendants and opposing the wholesale reinstatement of all of these members of the McDonald class. I think Celeste said something this morning that I think is so true. The women who were certified in the McDonald class had not when they left for marriage. They had not filed a grievance. They had not filed an EEOC complaint. Arguably, they perhaps didn't realize what their options were, but Celeste's comment, I think, was so true, and that was the McDonald class members were the honest people. Because when they married, they just sort of quietly went away. Maybe they didn't like it, but they left. Unlike the people like Celeste who decided, and there were a number of them, who tried to continue their job and hide
10%.
hide the marriage. And there were supervisors who made a career of perusing hometown newspapers for marriage announcements. So, I mean, that's how serious they were about it. And actually, Mary Pat, you had a story about that, how a Northwest flight attendant was discovered to be married.
My ex-roommate, she married, and she was from Montana. She was, both her parents were dead, but she had these distant cousins in Montana. So a Northwest Airlines sales rep was traveling through Montana, and her cousins go up to this sales rep and said, "We have a cousin. We know she's married, but we don't know her last name, and she lives in Seattle. Her name is Viona, Switzer, but we don't know her married name." Well, he comes back to Seattle. The management finds out she's married, and she's out of here.
They were always on the alert for people violating their no marriage rule.
I want to say what an important part the unions that represented flight cabin attendants, stewardesses, played in this whole picture. I always like to mention the name of Colleen Boland. She was president of the stewardess unions at the time. I got to know her. We became good friends. About that time, we also both became co-founders of NOW. So the unions and somebody like me at the EOC were always in touch on these matters.
Jenny, did you want to ask any questions here?
Well, I just wanted to tell you all how much I have been so inspired and fascinated by these stories. It shows me how important it is to have people like you who could come forward, and how much progress that we've made. Because for me, hearing some of these stories, it is so hard to believe that was the law before. Today, in talking to workers about their situations, I've had women say, well, my manager says the way to sell more is to stand outside of the store, unbutton my blouse, and hike up my skirt, right? So still today, women are experiencing those stereotypes. Other women have said, well, I went up to a senior manager and asked for advice on how to get ahead, and she said, well, why don't you try wearing more makeup and dressing up more? So we do see that still today, some of these biases continue to exist. But what it makes me hopeful, hearing your story, is that 50 years from now, or even before then, some of the stories we hear today will sound as foreign to people in that generation that your stories, sound today. So I thank you for sharing that history, because it's so important for us to be documenting it so that we continue to remember it, because it provides a guide for us as we go forward. So thank you.
And I have another question. Thank you for that, Jenny. I want to open it up to questions from the audience. And I also, where are the folks who have microphones in the audience do we have anybody down here? Oh, okay. So if anyone has a question, please raise your hand. And while we're doing that, though, I do want to, one other question that I have, and Professor Strube, for you, and also for our chair, Jenny Yang, about the issue about class certification that you worked on. Because as you said, the litigation of these cases was so groundbreaking in so many ways. And one of the major issues was whether or not, in fact, you could even have a class under Title VII. And I want you all to know also that our chair, Jenny Yang, was one of the lead attorneys in the Dukes v. Walmart case that went up to the Supreme Court and decided a major issue about class certification in the last couple of years. But Professor Strube, you want to talk about that a little bit?
Sure. given that Commissioner Yang worked on the Dukes versus Walmart case where the class looked as if it was going to number about 1.5 million people, the idea that the McDonnell versus United Airlines class numbered 1,800 and that posed logistical problems and lots of shock and awe for the judges and the lawyers at the time may seem like small potatoes. But it was by no means settled back in the early 1970s whether you could have a class composed of people who had not filed charges with the EEOC about the allegedly discriminatory practice. And as Patricia pointed out, most of the people in the McDonnell versus United Airlines class had not filed charges. A woman named Mary Sprogis had filed a lawsuit in Chicago against United Airlines, challenging the no marriage rule back in about 1970. It, like all of the other United litigation in Chicago, bounced up to the Seventh Circuit and back down. These cases were a huge part of the Seventh Circuit's caseload for quite some time. While the Sprogis case was kind of bouncing around the courts, a woman named Carol Romasanta had filed suit on behalf of herself and other United stewardesses who were fired under the no marriage rule. And Leanne McDonald was a part of that group. At that point, the court thought there were about 140 people, as best everybody could count in that group. The first odd thing was the idea in the Sprogis case that the Seventh Circuit said it was okay for the trial court judge to first decide the merits of Ms. Sprogis' claim against the airline and then decide if there was going to be a class action. That was the trial court judge's plan. The Seventh Circuit said, yeah, okay, that makes sense to us, although Judge then, later Justice Stevens at the time said, he was the dissenter who said, I don't think this makes sense under the law or any other way. But in any event, what happened was that when the case went back down, the trial court judge decided not to certify a class, but rather to permit the 12 or so women in the group who had actually either filed a grievance with their union or filed an EEOC charge to intervene in the first case as named plaintiffs. Everybody else was out of luck. So at that point, the women led by Ms. McDonald appealed to the Seventh Circuit and said, we understood that the plaintiffs in this case were going to look out for our interests, that they were going to appeal if the judge didn't decide to certify a class. That case went all the way up to the United States Supreme Court on the question of whether it was a timely appeal when Ms. McDonald, on behalf of the class, had waited until after the Sprogis plaintiffs had decided not to appeal, to file her appeal of the court's decision and the class action. And the United States Supreme Court said, no, that was a timely appeal. That was appropriate based on the facts. So when that came back down from the Supreme Court was the point at which it was certified as a class and then assigned to Judge Moran, who discovered, to his horror, I think, that there were somewhere between 1,100 and 1,800 women in the class. Nobody was quite sure, but it was one of those situations where the class kept growing. So the next class issue, or one of the most important class issues, is the one that Patricia alluded to also, the question of The default position under Title VII was if you were illegally terminated from your job, then you should be reinstated with back seniority if the employer works on a seniority system, and back pay. The back pay was not so problematic. It cost United millions of dollars, but that was not the problem. The question was, if you reinstated 1,000 or 1,500 flight attendants with full back seniority, what was going to happen was that a corresponding number of the then incumbent flight attendants were going to be furloughed by United, because United didn't need 1,000 or 1,500 extra flight attendants. And so it was the McDonald case where the court grappled with, and eventually the Seventh Circuit upheld, the idea that in some circumstances you can't award full retroactive seniority for all purposes if that award is going to mean displacing or significant hardship to incumbents in the position who haven't done anything wrong. So I think those were the two major issues: the timeliness questions for the class, and then the question of how you deal with reinstatement with seniority.
Jenny, what would you think about having to litigate that today?
I think those decisions still remain important today in class jurisprudence. I think what a lot of this has shown me in my work in class actions is that so many of these procedural rules really have a substantive impact on who's able to come forward and challenge practices, because very often it is only through sort of a collective picture of what's going on that the true sort of barriers are identified. And having the ability to come forward also protects people, because it's very easy to be retaliated against and fired for coming forward, especially when you're currently employed. It's much harder for an employer to fire, a large segment of their workforce. So there's also that support in being able to be a part of a larger class. So I think that it remains, important issues for us today to look at how some of these procedural issues are really substantively impacting the ability to enforce the law.
Let me ask if there are any questions from the audience. And before I do that, I do want to ask, are there any other flight attendants with us in the audience today? And if there are, could you please stand? Could you please stand? Thank you all for being with us. Okay, any questions here? Go ahead.
One of the things that I realized after flying for 45 years, and I started in 1968, just before the marriage rule changed.
There we go.
Just before the marriage rule changed, I started flying. And I was just like every other stewardess. I just wanted to be a flight attendant, and I wanted to travel all over the world. And I didn't really think, I knew that retiring at 32 was illegal. And I mentioned that during training, and I was told, well, you could leave. That's your choice. So I knew that that was a problem. But one of the ways that we, as flight attendants or stewardesses, were able to move this forward was because we were not supervised. Once that door closed on that airplane, it was us. And nobody was watching over our shoulders. Nobody was listening to our conversations. They thought we were, empty-headed, pretty little girls, and we were going to be gone in a couple of years. And because of that, we were able to build relationships with each other of great trust. And you have to remember, we were away from home for the very first times. I was 20 years old when I started flying. And in 1969, I started volunteering to do union work, and Celeste trained me in grievances. So, this was 46 years ago. And that and today I notice women are starting to establish associations where they have an opportunity to communicate with each other away from their work. And I would say to you that that is one of the most important things that groups can do today, is find a way to talk to each other when you are in a safe environment where you can build trust. And that will allow people to move forward and get the equal employment opportunity and the equal treatment that all human beings deserve. And we were lucky. We were very, very lucky that we were able to do that with each other.
I would say that you were all learning how to 40-some years ago, you were all leaning in before we were all told to lean in. So, any other questions here from the audience? I think there's one over here.
I just have.
How about?
I have a comment. I'm Tom Allison. I was a young associate in the early 70s at Cotton Watt, Jones and King, where we were the lawyers for Mary Burke Sprogis. And
let's trade microphones just to be sure here that.
Yeah, that one just doesn't work.
And I just wanted to, and so I was involved in those cases at the early part of my career. And I just want to say a couple things with respect to what Ms. Fuentes said. I thought the litigation was really vexed by that whole BFOQ question. And what was it, was it a BFOQ to be a flight attendant, a woman in the first place, or was it a BFOQ to be unmarried? And I think what unlocked that was the handful of male stewards on the Hawaiian runs that made it easy to say, well, look, you got these stewards over here who the rule doesn't apply to, but if they hadn't had any stewards, I'm not sure how that litigation would have turned out at the beginning of Title VII. Another interesting thing which Professor Strube touched on was the role of the union in the back pay. The union financed and drove the Sprogis litigation, which made the finding that this was all illegal. And then the union convinced Judge Perry at the end of his decision to say, after you've won, all right, now it's a class and it applies to everybody. But then the union got in the box where it had divided interest between the people who wanted to come back and the people who represented. And Judge Moran really rolled up his sleeves to work on that, I think. And if you read Judge Moran's decision and the Seventh Circuit's decision approving it, he gave the flight attendants all the back pay, all the monetary aspects of this, but with respect to seniority reinstatement, he froze their seniority, as I recall, at the moment they left. Yes. So they didn't accrue seniority while they were gone, but they kept all the seniority they had when they left. But the way these cases all fit together was really fascinating. Everybody was building on everybody else.
What Judge Moran did was actually even a little more complex than that. He froze the women's seniority for purposes of bidding into lines and domiciles, airports where you were based, but he gave them full retroactive seniority for purposes of pension and the company-wide benefits that would not affect their ability to displace the current incumbents.
Let me see if there's one more question from the audience. Yes, please, there in the middle.
I think one of the things that has not been emphasized enough is what a cultural shift this caused. I was a young woman when these women were fighting these battles, and my understanding of what jobs a woman could do were nurse, teacher, secretary, and flight attendant. But flight attendants had, as I understood it without anyone telling me, a BFOQ of looking a certain way, grooming a certain way, and having a certain body type. And so those were things that flight attendants fought against. I don't know if you have any stories about the grooming stuff, but I know that you were told to wear your hair a certain way, you had to wear your makeup a certain way, you had to have lipstick, it couldn't be red, et cetera, et cetera, et cetera. And so this caused a much larger cultural shift than even the labor aspect of it. It was playing out in the newspapers like the headline said, you know, you can live in sin, but you can't get married. Do you have any stories about the other grooming? I mean, it's certainly humiliating to stand on a baggage scale and be weighed, but there were other things as well.
Okay, let me just say one thing. Mary Pat has something, but let me just say, when I graduated in 1966, we all graduated with the identical haircut, the same color of eyeshadow, and the same color of lipstick. It was all very cookie cutter, and it was monitored on a regular basis.
The weight check created neurotics. I have subsequently found out from friends that if one doctor prescribed a diet pill to one flight attendant, she passed that around to all the others who were on weight check, and they passed these diet pills back and forth, especially the night before they were going in to be weighed. They would not eat. One girl told me that she flew all the way to Tokyo and back without eating because she knew she had to be weighed when she returned on that trip.
I would just like to say one thing. There were so many discriminatory battles, and we won them all. And somebody said to me not too long ago, "You're not special anymore."
And did you say, and I wear that proudly? So. I think that we're probably getting close to the end of our program, although we could probably go on all day long with so many more questions that all of us have for all of you. I want to thank so much, and I just want to ask in particular, and it's a quick answer from each one of you, and including you, Sonia. Did you have any idea when you brought these cases what you were getting yourself into?
Good
What do you
Lord,
mean
no.
by what I was getting myself
Well,
into?
just in terms of how long these things would take and the issues and...
Well, I'd like to make a statement that's related to that.
Okay.
You've heard a lot of talk today about how courageous all of us were. And I'm not speaking for the other women here, but for myself, I hear this all the time, and I am not a courageous person. When I see something that I think is wrong, and nobody else is doing anything about it, I feel it's my responsibility to do something about it. But I'm not courageous. I never had anything much to risk. If I was going to lose my job, my father was always there to support me. So I don't know that it takes courage. It just takes a feeling for justice. Another answer to your question is more with regard to now than the EOC. When we founded NOW in 1966, none of us had an idea of how it would revolutionize this country and the world. All we wanted was that women should be allowed equality in getting into colleges and universities and in getting promoted and hired on the job. We had no idea of the revolution that would follow from that.
Well, I think for me, I was once told by a supervisor that I was too tenacious. And I looked it up, and I really was bullheaded. So, no regrets.
Well, when I went to see Michael Gottesman, I was really asking for my seniority and a $5 raise. I did not know about the Equal Pay Act or Title VII. So it was a 15-year education for me.
Tricia?
Yeah, I agree with Sonia. It really wasn't a question of courage. It was simply a question of fighting each battle as it came along because it wasn't fair. And if you could do something about it, you should try.
Well, I want to thank all of you for being such an example to all of us and the great work that all of you have done. we truly stand on your shoulders. Thank you so much. And I want to take a minute to introduce, to wrap up, Paul Malika from the American Bar Association for our co-sponsor today and for being with us today. Thank you.
Why is everybody sitting? Oh, he's good too.
So to Chair Yang and to Commissioner Lipnick and to IIT and to the pioneers sitting here, I thank you very much for the invitation to say a few words. The one thing that's been missing from this conversation is the voice of reaction. We've talked a lot about the pioneers, but what they were fighting against is nearly as important to discuss. And so I just want to lay a few words about the context of this discussion and also where we're headed. So if you can imagine, the mid-20th century was a time of huge change in our country, economic change. With the war came women entering the workplace. After the war was the first desegregation order for the armed services. Major transformations were occurring. And yet there was also a strong pull in the other direction. White men occupied almost all positions of responsibility. They headed the unions. They ran corporate America. They headed up almost every branch of government. And so this was setting up a titanic battle in the 50s and 60s to change the way our economy was organized and the workplace. My mother, who was born in 1931, herself wanted to be a flight attendant, and she met with the strongest and closest male reaction she could, my grandfather, who had known waves and whacks in the Pacific and said, no, you may not serve as a flight attendant. So instead, she went to Pratt Institute and became a pioneer in the field of drafting. She was the first woman hired at then called Sperry Gyroscope. And so she had her own opportunity to be a pioneer, but it was an inspiration to me and why I'm in the field of representing employees. So with the changes of the Civil Rights Act of 1964 and Title VII in particular, there was a need to change the way we thought of the workplace and the economy. But all of the sources of reaction were still there. A sense that men were breadwinners, the sense that men were also expected to retire at a certain age and make room for younger men to take their place. The idea that white, mostly men, would hold all the jobs of responsibility. So everything had to change. And it required lawyers on both sides to reach an accord and to gradually transform the legal landscape that became the world that we live in today, a very different place. To talk about BFOQ, for instance, you're right, there it was, borrowed from prior law, that there could be a BFOQ, bona fide occupational qualification defense. And United, Northwest, and other airlines fought very aggressively for the broadest reading of BFOQ. Here we are in 2014, and the only cases I can think of where BFOQ is raised anymore is prison guards. I'm hard-pressed to think of any other example today, and that was because lawyers fought very hard to interpret the vague language of Title VII and to give it life. And so there's a great deal of credit to the lawyers who brought these cases, but also due credit to the lawyers on the other side who did defend their clients, the employers, but also persuaded them that it was time to stop fighting and to start changing. So I speak as a representative of the EEO committee for the Labor Employment section of the ABA, thousands of employment lawyers who represent employers, employees, unions who serve in government and academics and have an abiding interest in the improvement and continued change of in the workplace to look for equity for all employees, all people entering the workplace. The work is not done, or else Chair Yang and Commissioner Lipnick and other people could just declare victory and go home. We were talking about the look policies that were in existence in the 1960s, but policies like that still exist. The Abercrombie and Fitch case, which is in the U.S. Supreme Court, in which the EEOC litigated in California successfully to, I believe, a settlement that barred the wearing of hijabs in the workplace. And Harrah's, a major chain of casinos, that imposed a look policy that required women to wear makeup, even when they felt it was inappropriate or there were other reasons why they shouldn't. So it's not like we are completely free of the challenges that existed even 50 years ago. And there are other workplace challenges, other workforces, and they're facing the same kinds of problems in 2014 that the women of the 1960s, the pioneers you see before you, face today. The plight of migrant workers, of immigrant workers, of transgendered workers, of people who are now having to make a new place for themselves in the 2014 workplace. So that's what the EEO committee of the ABA section of law, labor and employment law work to improve and make progress on. It was very, very inspiring to hear just how much work had to be done in the 1960s, and I just want everybody to know how grateful I am for that pioneering work and a recognition that it's a fight that never ends, but that we will always seek to find equity for all people. Thank you.
I think, did you have any further comments here? Okay.
Come up here with some trepidation. I'm the only thing that stands between you and lunch. But will you indulge me just a minute of personal privilege? This has just been an absolutely incredible, eye-opening, inspiring program. I've had the wonderful experience of being in my 35th year here at Chicago Kent, and I estimate I have probably taught between 1,000 and 1,500 women law students, most of whom have gone on to very fulfilling careers and very fulfilling positions of leadership, in contrast to the oppressive policies we've heard about with respect to flight attendants at United Airlines. One of them, an African-American woman, is currently Labor and Employment Counsel at United Airlines. Even more fulfilling for me, as fulfilling as my role here has been, even more fulfilling for me has been my role as a father and watching my daughter develop as a scientist, as a practicing clinical medical physicist on the verge of getting her PhD. None of that would have been possible without the courage and the vision and the pioneering efforts of these women and the others like them. And so on a very personal level, I want to thank you for all that you have done. And I want to thank all of you for coming today. And one last show of appreciation for this incredible panel. We are adjourned.